Welcome, everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services levels up your legal knowledge about an area of law that we practice in. I'm attorney Susan Ingles here with our producer, Kenneth Elliott. You are viewing attorney Taylor Ott in our Orangeburg office, and today Taylor will introduce you to the new law that aims to protect older Americans here in South Carolina from financial exploitation. Just recently went into effect, I think in May. But before we get started, we want you to know that this is not legal advice. It's just general information for the public. If you do need the help of a lawyer, you can always call our intake line here at South Carolina Legal Services or apply online. That information will be provided at the end of today's presentation. And also the webcast will be posted on our YouTube channel, usually within 24 to 48 hours of the presentation. So be sure to check out our social media and like and subscribe to get all the up-to-date information that we provide on Level Up Law and other online resources that Legal Services has. And those websites and social media handles can also be found at the end of today's presentation. So without further ado, I'll turn it over to attorney Taylor Ott. Taylor, take it away.
Aha, okay, so I'm pretty sure everybody can hear me. That's usually where I start with these presentations. So like Ms. Ingles said, my name is Taylor Ott. I'm an attorney with Legal Services. I'm our elder law unit head. And so working with adults primarily over the age of 60 in a partnership with the Office on Aging. I could be getting that wrong. Formerly the Lieutenant Governor's Office on Aging. We provide services to clients that are over the age of 60 throughout the state of South Carolina. And one of the things that we frequently run into is either scams or financial exploitation. So really prior to the enaction of this statute, the tools for civil or criminal liability for those who may have taken advantage of a loved one or a family member or friend who had assets and is a vulnerable adult. We really had limited tools in the toolbox because it usually at the time that you're discovering some of these issues, the money's already gone. So the nice thing about the new vulnerable adult law is that it allows banks and financial institutions and other qualified individuals to actually actively participate and partner with those who may be caring for a vulnerable adult to stop some of this financial exploitation before it gets too far. So with that, there we go. Okay, so the nature of today's presentation is talking about this law, but also talking about, what individuals are involved as far as banks and financial institutions, but also what population are we talking about. So banks have always had the ability internally to combat fraud as far as the reporting that they have to do to state and federal organizations about the information they have. And with this law, the responsibility is kind of the ball is put back in the court of the banks and the financial institution as far as having responsibility to identify financial exploitation when it occurs and putting some tools in their toolbox of how to help. So with financial exploitation, like I just talked about, often by the time that lawyers may get involved or family members may really notice what's going on, that money has already gone. It's gone, it's not coming back. And so there's some nice things that happen in the statute and some helpful timelines that banks can basically freeze assets. So with this, the banks also are given they're given responsibilities and duties, but also some immunity from civil and criminal liability. So it frees up banks to do what they have the power to do, and using the ability they can see of having access to transactions and a history in a bank account to make reports to Adult Protective Services or law enforcement or the AG's office, but also have that immunity from prosecution if they're acting within the guidelines. So it allows, the law allows financial institutions, and there we're talking about banks, credit unions, or other financial service companies to either decline, delay, or report certain transactions that are suspected of financially exploiting a vulnerable adult, which we'll define in just a minute, or someone who's aged 55 years or older. Interestingly, here, seniors is defined as 55 and older. In other areas in the law, it's 60 or a higher age. And those reports to the responsible agencies are going to be DSS, which is the Department of Social Services. Within that is Adult Protective Services. Right now, I think there may be some transition from Adult Protective Services to another state agency at some point, but it will still be whatever office and whatever, if it's a cabinet level position, wherever Adult Protective Services is housed, or the Office of Attorney General of those suspected financial exploitation. And so who does it protect? That's an important thing. Who's the audience that the law is trying to address? And it would be anybody who's over the age of 55 and therefore defined as a senior for the purposes of this law, or a vulnerable adult. The reference in the statute, actually, it says, go here to look for who we mean when we say a vulnerable adult. And interestingly, that definition comes from, doesn't come from DSS itself, but it comes from the code sections talking about when we say a vulnerable adult for the purposes of Adult Protective Services, who are we talking about? So it's anybody who meets the criteria of they're over the age of 18, who, excuse my spelling error, who has a physical or mental condition that substantially impairs their ability to care for themselves. So they would have they may have the ability to perform what we call ADLs or activities of daily living, but they have some other impairment that may be physical, or it could be the result of some type of, so it could be they're born with it. So some type of mental or physical condition that they've had that's lifelong, could also be the result of some type of accident or other medical condition where they have a dysfunction or impairment that makes it so that they cannot adequately care for themselves. So it could be that person doesn't have a court-appointed guardian or conservator over them. That's done through probate court. I think we have other presentations on that. It could be somebody who just meets those definitions and might have a medical diagnosis or be receiving Social Security disability or something else, but they may not necessarily be in a Department of Mental Health or DDSN facility. However, if that person is in a DMH or DDSN facility, and usually you can only get there by a court process, that person automatically is considered a vulnerable adult. So you may have, that's a long way of saying that there might be some people in the community who are living and look like they're living independently that are vulnerable adults for the purpose of this law, or it may be somebody who's in a DMH or a DDSN facility. So just wanted to clarify, who are we talking about this protecting? And then what is financial exploitation? And this definition also comes from the statute. And so financial exploitation is the wrongful or unauthorized taking or use of money, assets, or property of an eligible adult. So financial exploitation could be liquidating a bank account for purposes that are not in the best interest of that vulnerable adult, or it could be the taking of other assets and property. This law is really just talking about, I'm assuming, whatever assets, or particularly probably liquid assets in a bank account, or other securities and commodities that vulnerable adult owns. This isn't going to relate to the taking of personal property or other types of financial exploitation. And that's going to be an act by a person who may have a durable power of attorney. They may have been appointed as an agent in that document, may have been appointed by a court as a conservator or a guardian So they're using the power that they have to act on behalf of that person or the trust that they've established for the purpose of defrauding that person and taking that money or those financial assets and not using them for the benefit of the vulnerable adult. If you are in a role, especially if it's a court-appointed role as a conservator or a guardian through probate court in South Carolina, you have a fiduciary duty that you owe to the person you're acting on behalf of. Probate code refers to it as an AII, alleged incapacitated individual, rather than vulnerable adult, but it's the same idea. So that fiduciary duty says that you always have to act in the best interest of the person that you've been granted that power on behalf of. And so when you are dealing with their funds and having access to their bank account, when you spend the money, when you purchase assets on their behalf or transfer them, you have to always act in their best interest. And you also have the other side of that fiduciary duty is a duty against self-dealing. So you can't use the access to those funds in the bank account to benefit solely yourself. It wouldn't prevent there being a collateral consequence, like I'm acting on behalf of the vulnerable adult using these funds and I'm paying the mortgage for the house that we both live in, like if it's a spouse. There is the collateral consequence or the happy benefit that it also pays for your roof over your head, but the primary purpose would have to be for the best interest of the vulnerable adult. That was a sidebar, I apologize. So you're also could be using that relationship that you have with them or the court-appointed role to convert money or assets to deprive the eligible adult of those things. So you're either using the control or using it to convert the assets. The legislation that we're talking about here has two parts, and it's rules that mirror image each other as far as dealing with bank transactions and then transactions involving securities. So the first set of things we'll talk about involves banking. So that would be traditional banks, credit unions, where you have your traditional checking account or savings account, and then securities, which could be where a financial advisor may be involved. So investment accounts, anything where you've got stocks or commodities that may be outside of traditional banking. So under this law, it's not a burden that is placed on the bank or the financial institution. It basically allows them, if they choose, to participate with state agencies and law enforcement to investigate and prevent financial exploitation. So they have this power and this tool, they have their own tools and rules about financial exploitation, but this kind of opens the door to really allowing them to act in a way where they've got some immunity and some responsibility and some quick timelines. So it gives them the ability to use the unique vantage point that they have and the unique perspective they have as far as access to records to prevent financial exploitation. So banks can, but don't have to, decline or place a hold on any transactions where they suspect financial exploitation. And the interesting thing here is it's not just the account of the vulnerable adult. A lot of the times you may see a vulnerable adult directly benefiting from a special needs trust or other way that a bank account may be set up so that they're not the primary holder of the bank account. So the transactions that they can place a hold on are not just that, let's say I'm a vulnerable adult. It wouldn't be Taylor Ott's checking account. It could be the special needs trust where I am the beneficiary of the trust. It could also be that trust account. And it could be the account of the person who you suspect is engaging in the financial exploitation. So if I'm the vulnerable adult and I have an agent, a conservator or could be an agent under a durable power of attorney, that person who you think is engaging in the financial exploitation, you can also freeze or delay transactions in their bank account. So it's kind of far-reaching. And if the bank declines a transaction or places a hold on transaction, so once they decide to get involved and either slow down or try to prevent that financial exploitation, they have to this is interesting, they have to make a reasonable effort to provide notice to all the parties involved in that transaction that the transaction was declined or a hold was placed on them. And so you've got to let everybody know, hey, you're paying money from this account to pay for, let's say it's a mortgage. So you would have to let the account holder know, the mortgage company that's receiving the money know, hey, we have placed a hold on or frozen this transaction. And they also have to report the incident to the appropriate investigative agency. So the statute allows reporting to could be Adult Protective Services, it could be local law enforcement, it could be the Attorney General's office, and there's a way of determining who's the appropriate agency to report. So they can place that hold for up to 30 days while they are, investigating themselves, that financial exploitation. And it could be, so 30 days is the initial period where it could be held. It could be a longer period of time if a court orders it to be held. So if somebody had started some type of litigation and the court says you have to hold those funds or that payment for more than 30 days. And they could also hold it for a total of 55 days if law enforcement requests that hold. So if, let's say, some type of transaction takes place, they report it to law enforcement, the bank themselves could hold it for 30 days. But law enforcement could, even without a court order, while they're conducting their investigation, could ask for an additional 25 days, bringing that total hold up to a total of 55 days while that investigation continues, which is nice, gives you a window of time to figure out what's going on. And so since we're placing this ability, not a duty, but an ability of a bank to hold transactions and report decline payments and up to 30 or possibly 55 days or longer if there's a court order, it's important to make sure we also understand that they're provided some immunity, but only under certain circumstances. So if the bank or, and later we'll talk about the mirror image that's provided to, so when I say broker dealer, that's the part that we'll talk about later, but here it's also applied to banks. They're provided immunity from and it's all types of immunity, criminal, civil, and or administrative liability. It's basically all the liability you could face for some type of action. So any liability they could face related to declining or holding that transaction or taking further action, so reporting that to law enforcement. The bank is protected from liability if they're acting in good faith and its decision is based on the evidence it has at that time. So the statute has a definition of what that is, but the bank can't just hold a transaction or decline a payment without acting in good faith or without having some type of basically its own evidence that financial exploitation was occurring at that point. So there's a responsibility that the bank has to act in good faith. So you're not automatically a bank is not automatically going to get immunity or protection from criminal and civil and administrative liability unless they're basically, acting in good faith. Interestingly, that immunity is not absolute. So the vulnerable adult, if a transaction is held or a payment withheld, and that could be mortgage, obviously there are going to be consequences for a mortgage payment being withheld from a bank to another financial institution. It could be that there's late fees added, Lord forbid it cause foreclosure proceedings to start. The vulnerable adult can bring basically a private suit in circuit court for civil liability against the bank. So that's the one type that even if the bank is acting in good faith and its decision is based on evidence it has at that time for holding the transaction, declining the payment, reporting it to law enforcement, the vulnerable adult themselves still has a private right of action. So I just thought that was interesting when I was reading through it. Banks are required, any actions they take, so if they decline a payment, hold a transaction, or are going to investigate it themselves, they have to report their actions to Adult Protective Services, which is DSS, and law enforcement. So they can't act without also reporting it to law enforcement. And it's in the sole discretion of the financial institution whether or not they're going to place a hold on any transaction. Obviously, a court could order something, or it could be something where, as the result of a report to law enforcement, a court takes an action. But initially, it's in the right of the financial institution to make that decision. When they make this report to law enforcement, if the law enforcement or the investigative agency like Adult Protective Services asks for information, the bank is going to have to turn over or give reasonable access to records related to that financial exploitation. And that could include historical statements or recent transactions. So they're going to have to basically show their cards to law enforcement or an investigative agency about what's been going on that causes them to think that there might be a financial exploitation going on. So then this is the part of the presentation that deals with either transactions involving securities or qualified individuals. So that might, here we're talking about a financial advisor or somebody else that is not a traditional bank or credit union. So in the same way, if a qualified individual, so we can use broker dealers, but sometimes the word's used in the statute. So if they think that financial exploitation is going on or has been attempted, they have the ability also to report. Notice here the word is may promptly notify the agencies. So again, there's no requirement that they have to notify the agencies when they are seeing this occur, but they do have some tools should they choose to get involved. So they also are immune from the administrative or civil liability from making this report, kind of like what we had talked about with banks. And the qualified individual can notify they have that same responsibility to notify. And this is interesting, it's not a must here. So with the banks, if they're going to freeze the account, they have to notify the people involved with the payment. And here with seems to be one of the differences with the qualified individual is that they may notify a third party involved, an agent of the vulnerable adult or somebody else designated as a contact or the person themselves. And also, like with the banks, they're immune from that liability as long as they are acting in good faith. So let's see, is that the same? Okay, there we go. And broker dealers are given the same powers as with the banks. They can withhold those transactions or those payments, and that could be an example of that. Might be, they can refuse to release a stock dividend or the liquidation, selling the proceeds from selling shares in a company, refuse to release those to whomever the vulnerable adult may have designated the payment should go to if they think that that exploitation is occurring. And they have to, within 2 business days, let everybody know in regard to that transaction that the payment has been stopped or delayed. So the timeline here is within 2 business days. So also the same thing with banks of having to notify people involved with that account. And then they also have to conduct an internal review. Once they hold that payment, they have to conduct their own internal review of the suspected or attempted financial exploitation of the vulnerable adult. And then, and I apologize. So they also have the same timeline of being able to hold that money for or stop the transaction for up to 30 days. It can be up to 55 if they have the request of law enforcement or Court of Common Pleas, so that's civil court here in South Carolina, if they have an order extending it beyond that. So the court could allow that money to be held up for more than 55 days. And again, as long as they're exercising good faith and reasonable, good faith and acting in reasonable care, they're going to be immune from certain civil liability. The broker-dealer, like the bank, has an obligation to provide records to the investigative agency or law enforcement, and they may need to have access or examine the book and records of that broker-dealer or that investment advisor. And again, with the banks, remember there was that, though they had some protection as long as they were acting in good faith from civil, criminal, and or administrative liability, the vulnerable adult could still seek basically civil redress or bring a suit in the court of common pleas against the bank for wrongfully withholding payment. The same thing here, the qualified individual, so the broker, the stockbroker, the financial advisor is not immune from those type of suits where the individual may seek court fees, attorney's fees, that sort of thing. So the alleged vulnerable adult still has some action they can bring in state court. Yeah, this is that same reporting. I think this is just an additional slide in regard to the period of reporting. So it's kind of a big deal when you think about the problems that we had before this law existed, where especially if you think of a bank that you really like, that you have a good relationship with, or the bank teller, the person at the desk knows you, or in very small towns like I live in, with community banks, that it is reasonable to think that a bank or other financial institution will have some knowledge of financial exploitation that goes on. And they may want to get involved and make report to state agencies. And so this sort of provides a template or some guidance for how they may choose to do that. And the limitation in this law comes from the fact that it is not a requirement on banks, but that they can choose to to hold the funds and sort of initiate or begin the referrals to law enforcement so the financial exploitation can be dealt with. But really, banks and broker dealers are in the best position to be able to identify financial exploitation, and certainly can do so before law enforcement or family members or other people involved with the vulnerable adult may otherwise become aware. I've had clients over the years where they did not, by the time they became aware of the financial exploitation of a loved one, when you went back and pulled bank records, had been ongoing for a significant period of time. And by the time they became aware of it, the assets that were left were a fraction of what that person had before the exploitation started. And so you are often left with very few, you're left with resources, but you're also left with very few legal remedies at the end of that, as far as what you may be able to do to address and deal with the negative consequences of that financial exploitation. And so if we are able to identify that earlier, and banks can get involved and can make these reports to investigative agencies and law enforcement, not only are you preventing the significant loss of assets, but really you're getting the information quickly to the right people to stop it from happening. And so you have preservation of assets, but also the access to information and records that is necessary for civil and criminal prosecution. And so it opens the door to more people being convicted and held responsible for financial exploitation, but also just also allows for the preservation of assets. So that's the end of the presentation. Just sort of a quick summary of what the law allows and why attorneys and other service providers to vulnerable adults and seniors are very excited and anticipate good things coming from the law now that it's gone into effect, and that we're starting to spread information about it and be able to use it in our work. So Ms. Ingalls, when she had started the presentation, had mentioned that this is not meant to be legal advice. This, because you've watched the presentation, doesn't mean that you're in any type of attorney-client relationship with me or anybody else who may present a presentation for legal services. If you are interested in receiving legal assistance, we have a 1-888 number. It's toll free. You can call Monday through Thursday, 9 a.m. to 6 p.m. to go through the process of becoming a client. That telephone number is on the screen, but it's 1-888-346-5592. You can also apply online. And then we have a YouTube channel, Twitter, Facebook, where we also have links and information in regard to other presentations that we've done on Tuesdays for more than a year, that you're welcome to go back and look at and provide a wealth of information. So that's it from me at this point. And I don't know that we have any questions or anything that need to be addressed at this point, but I'm done.
Well, Taylor, thank you so much. And I don't think we have any questions at this time, but that was a great presentation. It certainly is. It's so new that, you know, there's only so much you can say about it, and you did a great job of that. I think all of these agencies are, you know, kind of trying to figure out what's their role and what are they going to do. And it was interesting as you were going through that, you know, and you're right, the banks have that unique perspective when things like this happen. And one thing also that stood out to me is that, you know, if it's actually not exploitation or not some kind of financial abuse, it seems like the law does allow you to get a court order to actually release the funds before that 30 days expires. But as we know, as lawyers, it's hard to get something done in court in 30 days. So, you know, you'd really have to be jumping right on it, it seems like to me. And then the other thing I noticed was that those investment advisors and broker dealers, they do not have to notify the person that they suspect that is doing the wrong. You know, the abuser or exploiter. They have to notify everybody else, but not that person, which I guess is so that the Attorney General can do an investigation and not necessarily alert the person that they suspect of the wrongdoing. So that's just a couple of extra things that I took away from your presentation, which again was very thorough, especially on something that's just so new, and we don't have a lot of experience with how it's going to be handled. But I agree with you, it's going to be a really good, I think, extra tool for banks to be able to use, you know, their unique position to point these things out and hopefully get something done about it. And as you said, there's so little that we can do when clients come to us, because usually the money's gone and there's absolutely no way to get it back. But with this, there may be a chance that if the funds are put on hold, that you don't lose the money as the person being having the wrong done to them. So I think that's going to, hopefully, as it moves along, be really helpful. So thank you so much for an excellent presentation on that. Taylor Ott from our Orangeburg office at South Carolina Legal Services. And now everybody out there in our audience, thank you so much for attending today. And those who are watching the replay, we thank you for doing that. And if you found the presentation helpful, I'm sure you did, and if you think it'll be helpful to others that you might know, please do go to our YouTube channel, or if you're already there watching a replay, definitely share the broadcast, because we want as many people as possible to get this important information. And also, of course, while you're there, you should like and subscribe to our channel so you can get more information as it comes out on Level Up Law every Tuesday at noon. If you sign up for those notifications, you'll always know when we've posted a new one. And watch that social media, as Taylor mentioned here on this last screen, because that's where we announce the weekly subject for each of our Level Up Law episodes. And be sure to tune in next week for another episode of Level Up Law on Tuesday at noon, where Stephanie Vanderhorst, our employment law unit head will be talking about some of the important information surrounding employment and vaccination. So I think that's all we have for today. Thanks again for tuning in on Level Up Law. Thanks again to our audience and to Taylor Ott, attorney in Orangeburg. That concludes today's webinar. Thanks, everyone.